an attorney. She represents a lot of different artists around the state, but she's calls Lafayette home, and she's going to do a little overview of entertainment law, copyright, trademark, and intellectual property law for us. This is going to be a good opportunity to just kind of understand, like, if you have some intellectual property, or maybe you've created something that you want to protect the value of, or protect your intellectual property, this will be a good overview of some of the tools available to you. So I'm going to turn it over to Brad.
Hey, this taller. Hi, I'm Bradley. Like Kate said, I'm a lawyer, and I do work with musicians and filmmakers and also small businesses in terms of trademarks. So they're, in general, those, well, that's intellectual property, right? People have a vague idea of what intellectual property is, but not a certain idea. For businesses, it's often a very overlooked asset in terms of trademarks and patents, and especially patents, but in goodwill, if they're looking to sell those assets. For artists, intellectual property is the asset. And unfortunately, the laws regarding ownership of intellectual property, in particular copyright, can be kind of complicated. So in terms of artists and creative types, leaving their art schools and creative schools and going out into the world of business, not only perhaps have they not studied how business in general works, but may not even understand the ownership nature of the property that they have. So I'm just going to, it's 30 minutes is a very short amount of time. I will have to announce that nothing I say up here should be taken as legal advice. Everybody's case is very different. And I'm going to rush through, and then we may have time for a Q&A after, and then I should be at some happy hour later tonight. Okay. So there are three basic types of intellectual property relevant to creatives. One, like I said, is copyright. Copyright extends to protection to all original works of authorship fixed in a tangible medium of expression. We'll talk more about that. Trademark, under federal trademark law, there's a federal right for trademark protection for any word, name, symbol, or device, or any combination thereof, used by a person to identify and distinguish his or her goods, or source or services, and to indicate the source of the goods or services. So I always think of it as a brand, like branding a cattle. This is Mr. Beausoleil's cattle with his B brand on his cattle. It identifies the source of the cow. That's all a trademark is, right? Patents. So Congress, both copyright and both Congress shall have the power, it protects. It gives inventors the exclusive right to their respective writings, inventions, and discoveries. Patent protection extends to any new and useful process, machine, manufacture, or composition of any matter, or new and useful improvement thereof. It must be novel, useful, and original. Or another word that's often used is non-obvious. Patents are very utilitarian. When you think of a patent, think of a tool. Think of engineer. Patent attorneys either have to have a bachelor in science or pass an engineering exam. Patents are essentially useful tools and machines. People oftentimes get these three types of intellectual properties confused, particularly patents and copyrights. When you get into the world of technology and computer software and things, just know for purposes of today that most software, most apps that you might be developed is protected under copyright, okay, not patent. It has to be really new, really non-obvious. That's something different than putting a language together to be covered by patent protection. Okay, so the basis for intellectual property protection of copyrights and patents comes from our Constitution. Actually, there's an article, Congress shall have the power to promote the progress of science and useful arts by securing, for a limited time, to authors and inventors the exclusive right to their respective writings and discoveries. This is the federal copyright statute that describes where copyright subsists. And I'll read the first paragraph because it's important. It subsists in original works of authorship fixed in any tangible medium of expression now known or later developed from which they can be perceived, reproduced, or otherwise communicated either directly or with the aid of a machine or a device. Works of authorship include, but they are not limited to, the following categories: literary works, musical works, including accompanying words, dramatic works, including accompanying music, pantomimes, choreographic works, pictorial graphic works, sculpture, sound recording, architecture. You get the idea. What we typically can think of is art and creative products, right? One thing to note, in particular, in this first paragraph, it says that the rights do not subsist until the work is fixed in a tangible form, right? Meaning that if I write a song in my head, and we're sitting at a bar one night, and I tell you the words to the song, or I tell you my poem, and then you go record that song, technically I do not have copyright protection under the law. If I wrote those words down on a bar napkin and passed them to you, and then you went and recorded those songs, right, then I have copyright protection. That's something that's kind of often overlooked. In other words, you cannot copyright an idea, right? You need to make sure you fix it to something tangible. Also, it also does not say that copyrights or protection subsists when the copyright is registered with the Copyright Office. That's also a very common misunderstanding. You don't need to mail whatever it is to yourself in an envelope to prove it, to have copyright protection. There are definite reasons to register your work with the Copyright Office, but and we might have time to get to those, and I mean, oftentimes, in some cases, advise it, but it's not necessary. Copyright exists as soon as your work is fixed to something tangible. Got it? So there are 6 copyrights in any work, right, under the federal statute. There's the right to reproduce the work. There's a right to create a derivative work thereof, meaning that if I an artist, I've taken a photograph of something, one of those photographs. If a painter was then going to create a painting from those photographs, it's a derivative work, right? If you are making a screenplay from a novel, that is a derivative work. That's a right that is protected under copyright. To distribute, sell, pass it out, perform publicly, display publicly. And this one was tagged on in the 90s under the Digital Millennial Copyright Act, the right to perform a sound recording digitally. This one? Okay. So I deal a lot with music, and I know we as a city deal a lot in music. And in my opinion, almost the entire music business is built around the fact that in every recorded song, there are 2 pieces of intellectual property involved. And each piece of intellectual property contains the 6 rights that we just went over. The right to record, to distribute, to sell. Who can tell me, I mean the answer is up on the screen, but who can tell me what is one piece of intellectual property? The lyrics and the music, the sheet music. The other is the actual sound recording. This can get really confusing, right? Especially if you own both. Especially if you wrote your song and you recorded it yourself. Throughout, in all of the business, those are treated as 2 separate pieces of property. They're licensed, sold as 2 separate pieces of property. And the way I learned to understand it was thinking back kind of in the early American music days, like Tin Pan Alley days and stuff. We had with music publishers, what they did was publish sheet music, like for piano players, to sit, bar piano players, your piano at home, and they would sell sheet music in stores. That's music publishing relevant to the composition. RCA, the record company that would record somebody performing that sheet music, right, whoever wrote it, own the records. And that's if ever I get confused in the recording, ownership of the recorded song, that's how I think. So how is ownership vested? This is what I talked about when the creator fixes it to something tangible, right? You write it down, you record it, you've written it, it's yours. There's one exception to that, and it's called a work for hire doctrine, which is essentially if you are an employee of somebody and you create work regularly as part of your work, the employer owns your work. Or you have agreed to transfer ownership initially in writing. But exclusive ownership of a copyright cannot be transferred unless it's transferred in writing. Other than real property, physical property, land, it's the only type of property that can be exclusively or that has to be in writing in order to be exclusively transferred. So that's another important thing to remember, whether you, if you're dealing in the business of creative works. What if there are multiple authors? This is something that also makes the business, whether it's filmmaking, especially music again, confusing. Collaborative works, confusing. The default federal law is that if more than one person contributes to a work, they have an equal, indivisible ownership interest in that work. So if Connie and I are writing a song together, we're sitting at the bar one night and we're just writing down our song on a napkin, and I've got this great melody, and I've got it all in my head. And she just comes up with one lyric, and the rest of it, 90% of the rest of it's me. And we go do a little recording of that song, and Coldplay decides that they want to record it on our record, right? And it's just kind of advertised as my song. Technically, they have to get Connie's permission too. Technically, Connie's owed half the money that composition has earned because we've contributed to the work. Unless we have agreed otherwise in writing. And so this is for bands, for songwriters. It's oftentimes very important and never done because it's not fun when you're collaborating on something. You come into an ownership agreement in writing before the product is completed. Most of the time, people come see me when that hasn't been done, and there's all sorts of confusion. So there is a limited duration of the copyright, like it said in the statute. This has changed over time a lot by statute. But right now, it's the lifetime of the author plus 70 years. After that, it becomes in the public domain. So do you have to file a work with the U.S. Copyright Office? Most people think you do. Again, like I said, to have rights in your copyright, to have it protected, you don't have to do that necessarily, but there are plenty of reasons why you should. One, it helps people find you. It helps people find the author of a work if they're looking it up by the title. That could be useful. There's a bunch of features you can say. It's necessary for filing, sometimes in federal court, but more importantly, the most important reason I say is that it gives, in many cases, rights to attorney's fees and punitive damages in the case of infringement. So oftentimes, especially if you are not a popular, super successful monetarily artist yet, and someone infringes your work, and your work is only worth $500, you cannot afford to go file an infringement lawsuit in federal court against a big company, right? But have you registered it, It will deter people from infringing if they find it, if they know anything about it, and or it incentivizes you to go ahead with your infringement suit knowing you could get those costs back. And it's only $35 to register online through the U.S. Copyright Office. So if it was more expensive, I'd say, maybe not. But it's so cheap, it's often worth it. And you can register things as a series. So a whole album can be registered as one collective work for $35. It's totally worth it. Okay, like I said before, ownership interests are transferred either by work for hires or in writing. And like I mentioned before, if there's more than one collaborator on a work, you better have your ownership figured out and in writing ahead of time, if you can. Even, though by then it's harder to do, easier said than done. What is a license? So you hear the word licensing a lot, right? Other than, there's a thing, transfer of ownership, exclusive transfer of ownership is a sale, right? It's not mine anymore. I don't have any exclusive rights to it anymore. It's yours. A license is a grant to you to exercise a right, right? I've written a screenplay, I can license to a theater company the right to perform my screenplay. They are generally limited to time, space, and medium. So oftentimes, like a typical language in a license of a copyright will say something to the effect of, I hereby grant for a certain period of time in a certain geographic region, this, say, theater company to perform my film for 5 years. They get the exclusive right, I'm licensing the exclusive right for my movie to be shown in AMC theaters in the United States for X amount of dollars. More oftentimes, it's also very typical to see licensing language like, I hereby grant this certain record company the exclusive right to record my song in perpetuity throughout the universe in any medium known now or ever to become known, period. I mean, that's as close to a sale as you can get. Key language in a license is whether the transfer of the right to do something is exclusive or non-exclusive, right? Meaning if I'm going to license my song to be used in a film, and I grant them the right to use that song in that film in perpetuity throughout the universe in any medium now known or known in the future. And I'm an artist from South Louisiana, and this is a small film, and they've only got $500 to pay me. I better make sure I'm not licensing that song, granting them that exclusive right. Because that means my song then cannot be used in any other film, in any other media, throughout the universe in perpetuity. They better pay a high price. So I want to make sure my license is non-exclusive. Does that make sense? I don't know, how am I doing on time?
You're good. 7 more minutes.
Okay, so I'm bringing up fair use because it's come up a lot, just kind of, not even actually in my practice, just in graphic design work that's come across my desk for promoting certain events and things the past couple months. Many artists have an idea of what fair use is, but let's read what the statute says. The fair use is an exception to copyright protection. Fair use is the exception for the owner or the author of the work having the 6 exclusive rights that we went over: the right to reproduce, the right to distribute, the right to perform song. And meaning that somebody can do it without your permission in certain circumstances. So the fair use of a copyrighted work, including such use by the reproduction in copies or phono records or by any other means specified by that section for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research is not an infringement of copyright. In determining whether a use made for any particular case is a fair use, the factors to be considered shall include the purpose and character of the use, the nature of the copyrighted work, the amount of the work that is used, and the effect upon the potential market for the sale of the work. Whether something is parody and whether something is copied is a very subjective determination. There's no black or white rule, and two courts will rule two different ways on the same things every time. But fair use is specifically an exception to copyright infringement under copyright law. It does not mean that someone can parody a work in a promotional poster for an event or for a company or for something like that. And we're going to talk about trademarks in a second. It's only an exception in the world of copyright, not in trademark. It doesn't apply. Public domain. People get whether a work it's fair use to use a work or in public domain often confused. Public domain just doesn't mean it means it's just not under copyright protection anymore. It means that in most cases it's that the protection, the rights in it have expired. So folk songs are a good example of that. Any Cajun song written before 1920 something is now in the public domain, and no one owns any exclusive copyrights in that. Okay, so I'm going to skip this, but this artist, Jeffrey Koons, I'll just say lost. He painted, or he made a sculpture of a postcard and lost in court when he argued fair use. And then he painted these shoes in this painting and won in court when he argued fair use. In class, we'll get a lot more detail about that. That's info on registering the copyright, blah, blah, blah. Okay, but I need to get to trademark real quick. So back to a trademark. It's a word, phrase, symbol, or design that identifies and distinguishes a source of goods from one party of those from others. A service mark is the same thing. It just identifies the source of a service as opposed to a good, such as Mr. Beausoleil's cow, like I talked about. You register, most trademarks should be registered with the Federal Trademark Office in order to be able to enforce your rights throughout the country. And then you can also register at an international base to be able to enforce your rights internationally. Most business now, even if you are a local crawfish restaurant, is interstate, right? Is people come to town, they're visiting, they're looking at your advertisements on the web. Most services and goods, even if they are hyper-local now, are almost all fall within federal jurisdiction. So you might want to consider federal trademark registration. I was at Zach's office the other day talking about, I have a couple of local food production clients who perhaps waited too long to register their goods with the federal register. They waited until they got some big distribution deal. And by that point, all their labels have been printed, the goodwill has been up in their brand, everybody knows the name of their product regionally, but somebody has another jam in another state with a very similar name, with a very similar logo style, and the U.S. Patent Trademark Office may deny registration for that purpose, and then if they do go sell in the region that the pepper jelly lady arguably could be subject to an infringement suit. So even if, when you're deciding on, it's a lot to think about, and trademark registration is not as cheap, unfortunately, as registration of copyright. If you do it online, the cheapest it could be is $275, and that's, in very limited cases, is that all is it going to be? And there's a bunch of reasons why that I don't have time to get into. But if you are starting your business, it may be an investment to really think about in the beginning, work with your graphic designers, working on your logo, working on your name. You might want to be sure, if you have aspirations of going big, just put that in that initial financing budget and just go ahead and do it. I will also say this, the number one reason trademarks are denied registration federally is because the point of it is to make sure that your trademark is unique enough to not cause confusion of the source of another product or service. So if your mark seems confusingly similar to another mark of another similar good being provided in a region where your good or service is being provided, you will be denied. So these are some typical trademarks. It can apply to the word, it can apply to a logo, and I put Star Wars and Mickey Mouse up here for the reasons in terms of businesses we're talking about entertainment law, and to distinguish what it is and what it is not. Is Mickey Mouse subject to, well actually I don't know anymore, I don't know when exactly he was drawn. He might be in public domain, but theoretically, is he subject to copyright protection? That's a drawing, yes. In this picture this is the exact picture I also took off of the U.S. Patent Trademark Register database. This is to identify Walt Disney Company is a source of good and service goods for they have all sorts of products. T-shirts, home products, bedding, you name it, they sell it. He's identified as a source of the goods provided by the Walt Disney Service Company. So do we see trademark rights can protect if he is used to sell somebody else's goods? So if somebody starts making a t-shirt with Mickey Mouse on it and selling it, like some vintagey looking t-shirt, we used to have when we were kids, you may get a cease and desist letter from the Walt Disney Company claiming you are infringing not only their copyright because you've stole the design and you have copied it and distributed it, which are 2 of the 6 copyrights you've infringed, but that you are also falsely identifying the source of the t-shirt. It's not coming from Walt Disney Company. Therefore, you are infringing their trademark rights. So both come into play. Trademark protection is actually not given for titles of movies or titles of songs. Okay. But Star Wars and the logo similarly does receive trademark protection as of all the goods that they produce, right? It's not protecting the title of the copyrighted work. It's protecting the identification of their source as the goods or services. So that's kind of a way to keep those things in mind. This is a federal statute talking about trademark infringement, and I call it infringement dilution. What can't you do to a trademark with a trademark? Any person who, in connection or with goods or services or any container of goods, uses in commerce any word, term, name, symbol, or device, or any combination thereof, or any false designation of origin, or false or misleading description, or false or misleading representation of a fact which is likely to cause confusion or mistake or deceive affiliation with a certain source of good, or in advertising or promotion misrepresents the characterization, the qualities, or origin of the cost or good. So trademark infringement and trademark dilution are kind of 2 different terms of ways in which a trademark can be infringed upon, or trademark infringement is essentially when somebody is copying your mark. Trademark dilution is when your mark is being used, and as a result, the value of your goods is declining. They're 2 kind of separate different things. But I have and Beyonce trademarked her name. So, and they tried to get in new trademark news. They also, what's the baby's name? Blue Ivy. They applied for a trademark of Blue Ivy. Why? And this is another reason when trademark rights manifest once a good is put into commerce. So, in a lot of trademark law, it's interesting. So Blue Ivy's name, P. Diddy and Beyonce applied to protect Blue Ivy's name as a trademark, but they're going to probably be denied because Blue Ivy doesn't have any goods in commerce yet. Just FYI. We'll see. And then the Mickey Mouse. All right, so I have like one minute for questions or something.
All right, I'm coming. Get y'all questions together. Some good free legal advice.
Nope, not giving any legal advice today.
Hello everyone, my name is Nicholas Lewis. My question is, as far as like for copywriting and trademarking, for instance, like if there was a talent show and it had like music, a talent show was a lip sync talent show. Is there any cease and desist that can go in because of the music that is being portrayed that they have copyright?
Well, so do you, if you, it's like the second slide, remember what the 6 copyrights are that are provided protection, right? So reading this, what do you think? Yeah. So performance of a sound recording or a composition is one of the rights protected by copyright. And there is statutory licensing. If y'all heard of BMI, ASCAP, or CSAC, or anybody, if y'all own a bar, public venue where they play music, you have to pay them money. What you're doing is essentially, long abbreviated story short, you're paying them money to perform the music and lyrics, right? So it doesn't apply to performing sound recordings publicly in the United States. It does apply to performing sound recordings in other parts of the world. It gets complicated. All right.
Question right here.
Okay, it's related to what you just said, Bradley, about can you play like a Spotify playlist or something at an event? Does that fall under copyright protection?
Mm-hmm.
Okay, so you cannot play like a playlist that's already...
Well, if the venue where your event is, or if you get some sort of event license from...
If you're not charging admission to the event?
They have these performance rights organizations. In short, they're called PROs, which is BMI, ASCAP, and CSAC. And there's one for digital audio recordings called Sound Exchange. And if you pay them, they have different types of licenses depending on the type of use. So, and for often for nonprofits, small events, or whatever, nothing. But there's no legal exception other than if it's a fair use purpose, like you're performing it for educational purposes.
Question?
And I'll be at the happy hour tonight too, if we're running out of time.
Sorry, I had one quick question. You said work must be tangible to qualify for copyright. What does that mean for digital art? Does it have to be actually physically printed or...
No, I mean, you can record, for digital art, it's fixed to something, it's in a tangible form.
Okay,
it's not
so
just
like
in your head, it's in a
stored
computer.
in is actually
Yeah,
considered
I can
tangible.
record a song on my iPhone, it just needs to be fixed.
One back.
A lot of videographers and photographers shoot public events, and because it's an open public event, those photos are used in marketing materials. Can you talk about when the people featured in those images have any rights?
So this is territory where you're getting into privacy rights, rights of privacy, rights of publicity, and that gets into when people have an expectation of privacy. So this will come up in filmmaking and stuff, right? You're filming at Festival International, or you're filming somewhere that's going to be used in a movie. Normally, if you're in a place, if you're just Joe Public and you're in a place where you have no expectation of privacy, then you have no problem with it. Practically speaking, what I often advise filmmakers to do is at least, depending on where you're going and the time, if it's just going to be a few people where you are, just get waivers and released and cover your ass just in case you don't have to deal with any problems or that they might have down the line. And if it's bigger spaces, I don't know if you've ever been into like a dance hall here or a bar or something, and they have signs up that says public filming will be here. They put up prominent public filming notices, and just take a picture that you did that, and that'll help kind of stop any claims that may arise. It doesn't mean that you violated anyone's rights necessarily by filming them, but what it does help do is nip you getting some sort of preliminary injunction in the bud that stops further showing of your video and just helps resolve a potential headache.
Okay, that'll be it. Ms. Blackman, be short for time.
Okay.
Thank you, appreciate it.
All right.